because we're going to talk, speaking about assignments, we are going to talk about writing a memo. Clearly your first assignment, authentic assignment task, is that you will be writing a memorandum of advice to a lawyer. Now, it's worth understanding how this task has been developed. In a law firm, junior lawyers are often asked to do research and to come up with sort of a first draft or some advice. Usually, particularly if you're a work experience students, what that would look like is that the partner would talk to you about something, you'd have some opportunity to ask some questions, then you would go away and do the work, and you would probably come back and talk to them. You might write an email or something like that. Here, clearly we don't have that opportunity, but what you do have is that ability to go a little bit more old school and write a memorandum of advice. Or this is more a memorandum answering questions to a supervising lawyer. It's the kind of thing I had to do a lot when I was a junior lawyer. And internal memoranda are a really common way for law firms to deal with each other. Although more and more you skip the actual memorandum, the formal form part, and you're doing this in an email. But for our purposes, because we're not only trying to expose you to what it's like to be a lawyer, but we're also exposing you to writing in a way that is required for good assessment tasks. So that means AGLC 4, referencing, setting things out, thinking about the rubric. So what I'm trying to do here is balance giving you information of the type that I would give any lawyer about how to write well on one hand, but also helping you be strategic so that you can get the best marks that you can possibly get on the other hand. So, flick here. Basically, this presentation, the first time that I ever did this, or put this presentation together, was for a group of young lawyers who were in a firm that I worked for at the time. So a lot of this is more real world than it is focused on getting the best marks. But like I've said to you before, the reason I do this job is so that graduates don't suck. So that's really what I'm trying to share with you here. Oh, I've got lots of hands up that I didn't notice, sorry. Let me just have a quick look. I'll finish making this point and then I will start answering some questions. So what I'm really trying to do here is share that information with you in a way that you could take this PowerPoint production later on and use this as you're going in to do some work experience or internship. Sierra, how can I help you here? Sierra, I need to unmute you, or you need to unmute?
The audio is cutting in and out.
Oh, is it?
Like, yes.
Oh, okay.
Yeah.
I really thought that the quality would be better here. Is that what other people are asking about as well?
Yeah. Yes. Yes.
Yes.
Yeah.
Okay. I need to look in the chat as well when that's happening. I think that's going to be a bandwidth issue. I'm really hoping it's not too much of an issue at my end, but I'll just continue being clear. Or do my best to be clear. I don't think there's much I can do about that. Sorry, a couple more hands clearly have different questions. Karen.
Now.
Oh, hi, Cathryn. No, it's just the same thing.
Sorry, now your audio is dropping in and out. Same thing?
Oh, can you hear me? Yeah, it's just the same as last night when you went into a particular screen and it just went a bit jumpy. So I don't know if it's because of this shared screen.
I don't know. Don't know, sorry. Yeah, I was thinking that might be the way it was being recorded last time. I can turn my video off. We could see if that helps. Would that be a good idea? I'll just ask this last question. Nahida. Nahida, do you have something you want to say or something you want to ask? you're muted or you don't have a microphone. I'm not sure which. Okay, just maybe put that into the chat. I will have a go. I will stop my video. And I'm going to open up the chat here so I can see if that's what it is. No, that's Q&A. Too many different places for you to talk to me. Maybe as you're going, if you can put questions into the Q&A area, or even just tell me if you're not hearing, and I'll just do my best to keep an eye on it, which should be a little bit easier when I'm talking to you. Audio is better, okay, clearly my voice is more interesting than my face. So let's get stuck into this. There's no one right or wrong way to write a memo. However, there is a pretty standard way to write a memo, and like anything, until you get used to doing something you can already do it the normal way, the basic standard way well, it probably isn't worth your time and effort to try and do anything particularly different. You know, the analogy I would use here is, you know, before you make a gourmet souffle, you should probably get scrambled eggs under control. So this is about the scrambled eggs, and then you can find ways to turn it into your gourmet souffle. So you can structure it to suit your purpose, and the purpose, though, I would always focus on what does your reader need to hear? What question has your reader asked? How best can that question be answered? So, structure will depend on purpose, needs, instructions. So instructions here means the instructions you received from your boss, your client, the person who's reading the memo. The nature of the issue itself, the level of complexity, the number of different issues you're dealing with, and the scope of the research, the amount of time you have, and similar kinds of things. So just want to, I mentioned this before, but the audio was going in and out. This slide pack draws heavily on some materials that were prepared for junior lawyers who are writing memos in practice. But the principles are great for thinking about memos that are written for assessment as well. I also draw significantly off a 1999 paper by Ganage about structuring legal memos. My very first point I would make, this is a new slide in this pack based on looking at what people did badly and did well the last couple of times. Try and solve the problem before you start writing. We get addicted to our own words. We find it very difficult to let go of the words that we've used. And so sometimes what I find, particularly early on, is the very first part of your assessment task will be quite in depth, but then it falls away when you run out of words. And part of being able to do this well is to work out where best to spend your time and effort. That it really makes sense to spend your words, quote unquote, as wisely as you possibly can, and that means spending more of them on the significant issues and less of them on the insignificant issues. And if you start writing too quickly, it's often very hard to do that. So the slide that I've got now, you should be able to see moving around. It's designed to sort of show you an approach that I use to really thinking about making sure I've covered everything off. So what I'm doing there is basically lining up facts along a timeline, usually in the order that they happen. Then I am mixing or identifying what the legal issues are and also what the rules are, and trying to align those. And I literally do that on the back of my door in my study with a range of different coloured post-it notes, just to work out what's important and what's not important. Now, some of you, that's too messy for you, you won't like it at all. I like the post-it notes because you can move them around. And you can change the order of things. You can decide that something actually isn't all of that relevant and stop using it. But others, you'll find that you work better in a linear way on a piece of paper. You'll find your own way of doing it. But there is some real benefits in planning in advance. This next one, another little sort of gift screen designed to do the same thing, is a way that I use to work out what the most important issue is. I just take the issues and then I basically map them on an X, Y axis. So Y touches the sky, remember? Y is how relevant, how important is this issue? And on the x-axis, I'm looking at how complex is it, how nuanced, how important is it and I'm thinking about it strategically here as well. How important is the issue to solving the problem? And also, how important is it to you showing off how deeply and nuanced you've understood the problem itself? And the more it fits up in that top corner, in that top looking at the screen right-hand corner, so high in relevance, high in complexity, they are the big issues. They're the ones that you should be spending the most time and effort on. For those of you who've got phones near you, you might want to capture that QR code, but there's two bits in the reading list. You can access them through the reading list in Canvas as well. Two sections from this particular book, the Nicola Corbett-Jarvis, Brendan Grigg book on effective legal writing. Unfortunately, the library only has hard copies of this book. It does not have soft copies, and apparently they're negotiating the license on it. But I've had two of the relevant sections, the one on writing memo and the one on writing letters, digitized for you. And the memorandum part is really useful, and I strongly recommend that you have a good look at that. Next, sorry, I'm just trying to make sure I'm looking. There's no magic to the actual formula, what a memo should look like. Absolutely no magic to it at all. Just pick a template from Word or whatever your word processing software of choice is, and it will look a bit like this. Who's it to? Who's it from? The date that it is submitted, a file number, and then a subject. Now, the subject is really the most important thing here from your point of view, because the subject area is your concise description of what this memo is about. Now, again, if the purpose of the memo is defined by what it is that the reader needs, one of the things that is important here is you give it a title that means your boss knows exactly what's in it, what's useful to them. So think about that. The rest of it should be pretty straightforward. Oh, goodness me, too many things going on here. Do you put in a table of contents? Completely up to you. I would think about it though, because table of contents will get caught up in your words or your word limit. A table of contents can be a really useful way for your reader to find things. It's kind of like, well done, it's like a good roadmap. If your document is 10 pages or more, I think it really is a very good idea. 10 pages or more excluding the bibliography. For a memo of this sort of size, it really needs to add value. And again, think about every word as like money here. Spend them where they help. So it needs, when you're putting a table of contents in, you want to make sure that it reflects a structure that's going to help your boss find what they need. When I say here, let Bill generate it for you, I'm talking about Bill Gates. And really, this is my reminder to myself to say to you, a lot of young lawyers think that they are too clever to be good at using software. But Word or equivalent word processing software, and really Microsoft Word is the one that is mostly in use currently. It is a tool of our trade. Not being able to use Word proficiently as a lawyer is like a carpenter who says, oh yeah, I'm just not that keen on being able to use a hammer efficiently. You should work out how to use these tools, and there are plenty of online resources. The university will help you with that. Lynda.com, or it's actually now LinkedIn Learning, has a lot of videos and a lot of instructional stuff, but a good old YouTube search will help you find out how to do things. And being able to set your documents up so they can generate a table of contents so that you can automatically cross-reference, those kind of things will be really invaluable skills to you in the longer run. They're not skills that people will praise you for because they kind of go without saying, and clearly you won't lose marks for not using Word properly. I can't and I wouldn't do that anyway, but these are the things that will make you more efficient at doing the job of lawyering, and really they're tools of the trade. Yeah, just to make that point really clearly, the table of contents will count towards your word limit, so make sure it adds value. If we're going to start with a memo with a background section or an introduction section, I think that personally that is very useful, and it's very rare not to include it, but some would say it's optional. This is where you describe the context, where you make a brief statement about what you've been asked to do and why you're doing it. It should set out what the scope of your instructions are, particularly if there's something that you've been told not to do or not to look at. You need to keep it brief, but this is the first thing that your reader is going to read. So this is a great place for you to put, I'm trying to think of the right verb, for you to provide a brief, succinct answer to the question that really matters. I think it is a really good idea to write it last, to write it when you write your conclusions, and then structure it there. This should be consistent with your conclusion. In most cases, particularly if lots of people are going to read something and it's going to move around and be read by people who maybe don't have access to the rest of the file or to the instructions that you were given, it is really, really useful to set out the material facts. So that doesn't mean to copy and paste the question from the assessment into the memo. If you do that, you're just using up a whole lot of words. What's important here, and what I'm looking for when I'm reading your description of the facts, if there is one, is have you been able to identify the legally relevant facts? So have you been able to identify what is material to answering this question? Less relevant here, because there is no need to cite the problem. Cite here I'm using as C-I-T-E. So in an assessment, just take it on the basis that you've been given these facts in the memo that Dennis has given you, and you've been told not to speak to anybody else, so you haven't. But in the real world, if you are gathering facts together from a range of different places, then I would be looking for you to include the sources of those facts so that people can go back. So I got distracted there because I heard a noise. I'm not sure if somebody tried to say something or not. Okay, raise your hand, I'm looking out for it, or throw a question into the Q&A. So I can see. I've got a couple of questions in there that I'm ignoring because they're just saying the audio is good now. If that changes, please let me know. Okay, Chronological order is often the best way to explain the facts, but not always. Some people will find it, particularly if we've got lots of things going on at the one time, you might find some kind of flowchart or diagram will be even more useful. Separating out and numbering facts makes it easy to go backwards and forwards to them when somebody's reading it, but think about your reader. If there's lots of backwards and forwards, it is actually can be confusing. So it might be that you want to structure so you've got facts, issues, answer, then the next lot of facts, issues, answer, if they're not related to each other. Really depends on the best way for you to communicate the answer. Some people will put a summary of the facts after the issue and the conclusion. It really depends on what you want to do. But in this case, you can assume your reader has provided you with the facts and you can incorporate them by reference. In other words, you can say, thanks for your memo, Dennis. Based on the facts set out in that, blah, 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 blah. So if you're going to reproduce the legally relevant, the material facts, there's got to be a reason for that because it's just between you and Dennis. So it might be that you need to pull out the facts that you've got more questions about, that you would want to get more information before the client was ultimately advised. Or it might be that you think something is key, some particular fact or issue is key and you want to highlight that. So again, words are like money, spend them wisely. I bet you wish I would do that, yeah? Why does this not work? There we go. The next thing that can be quite tricky is to think about whether or not you have made assumptions. Now, the nature of an assumption often is that you don't actually notice that you're making them. So you really have to stand back and think, how do I know this thing has happened? Or what do I need to assume to fill in the gap? So the nature of an assumption is something that we do to fill in gaps if we don't have all of the information. And sometimes they're really easy. Like you might assume, for example, unless you're told otherwise, that all of the parties are adults. And the reason that you make that assumption is because that Dennis is a lawyer and he would have pointed out that salient fact otherwise, or that everybody's of sound mind or something like that. Now, why make that assumption? Because actually that just means we're looking at a typical contract. But if that assumption was incorrect, then it may be that you can't enforce the contract against the person who is not an adult. And so when you're making an assumption, and I'm not suggesting you have to make this assumption, by the way, but if you are, I'm just trying to give you a working example, you might assume everybody's an adult, but you might make a little note. It doesn't even need to be a full sentence, really. Well, probably doesn't need to be a full sentence. I want everything to be sentences with verbs and full stops. But the very quick sentence might be that if this isn't the case, we will need to address the enforceability of the contract against the minor. Something as easy as that. So the point of this slide is that I want you to think about the consequences of the assumptions that you make, and I need you to articulate those consequences in a reasonable way. The other thing that I see happen often is, oh, it all gets a little bit hard, so what I might do is I might just assume blah, blah, and blah, because that gets me to the easy answer. I would really, really, really avoid doing that. Again, and you can see here that I'm working through this using the IRAC method. Issues. You need to state somewhere the legal questions that have been asked or the issues that you're considering in this memorandum, because these map the approach that you're taking to the problem. This requires you to articulate briefly, clearly, simply, concisely, precisely, and accurately, and avoid, I would suggest, synonyms unnecessarily. Break down each of your questions into all of the relevant sub-issues. Again, this is where your post-it noting can really help, because you can have a main issue and then you can link it to the sub-issues. You can work out which ones are important and which ones are less important. You can link then each of those to assumptions if you need to make them. Present your issues and sub-issues as questions. Present each of them separately. Is there a contract? In order to have a contract, is there offer? Is there acceptance? Is there an agreement? Blah, blah, blah. And deal with the most important issues first, and then their related sub-issues. Again, words, your time, it's like money. Invest them where you're going to get the most value. As a whole, it makes sense to begin with your strongest argument. Dennis, I think there's a contract here because blah, blah, blah. Dennis, there is no contract here because blah, blah, blah. Whichever side you land on, discuss, evaluate those major points. If, when you have time, go and consider the contrary point of view. Even if there is no contract, then blah, 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 blah. Even if there is a contract, then blah, 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 blah. I need you to be systematic about it, and I want you to try and have one idea in every paragraph. One of the things I often see is really, really long, exhausting paragraphs. They're exhausting to read. And think about your reader as you're doing this. Really, if you've got short paragraphs with a key point in them, your reader is more likely to pick up that point, rather than if you've got a long paragraph with 6 points in it, your reader might pick up 3 or 4 of them, but miss 2. Show the connections between ideas. Use linking words. Personally, I don't like furthermore, but doesn't mean you can't use it if it makes sense and it suits your style. However, though as a friend of mine always says, however is just a but in fancy pants. In contrast to, in addition, link the ideas together, but have separate paragraphs for each idea. And really try and conclude each paragraph, or at least each section of your writing, with a sentence that relates the issue discussed back to the topic. Think about using headings. Make it easy for your reader to navigate. How do you get through these issues? You're going to have to use some research tools. Now, it is perfectly possible to give an adequate, even a very good answer just using your casebook and the textbook. There's no doubt about this. And I know it's going to do some people's heads in, but this is not a particularly complex problem or complex set of problems. There's a couple of different issues in there you need to deal with. Start with your textbook and your casebook. Have a look also at the notes, the course notes, which I've started to update for typos that have been brought to my attention. Tiffany and Joey are in the lead at the moment for giving me information. I will be bringing chocolate their way as soon as I can. I might need to get an address and send them in a sanitised bag. Other things, online databases. Go and have a look at LexisNexis, Ostly, Jade. See if you can find cases with similar facts. Practice your research skills. Find the case that you think is key based on your textbook. Go and have a look in the databases to see if it's been subsequently considered. If it's an English case, can you find something that proves that it is good law in Australia? Now, conclusions and executive summary. Once you've got through everything, you're going to come up with a conclusion, right? Yes, there's a contract. No, there isn't a contract. One of the criteria in the rubric is, have you got a clear conclusion? Now, your conclusion, I look for it in 2 places. I look for it in the introduction, even if it's just that one sentence that says, Dennis, for the reasons I'm going to set out below, this is not, there is no contract here. Or Dennis, for the reasons I set out below, there is a contract here, whichever one it happens to be. Sorry, I'm muting a couple of people who I didn't realise were unmuted. That's where my noises are coming from. So you might have it as you might have a little executive summary at the very beginning. That's a really good thing if you can do it and you've got the words for doing it, the space in your word limit. But I'm still, even if you've got an executive summary at the beginning, I'm still expecting a brief, concise paragraph at the end with nothing new in it. The biggest issue I see, particularly from students who've come not from a humanities background, is that they introduce a new idea in their conclusion, and you really need to avoid that. I don't work on the basis that, and this is more a real life than in an assessment context thing because I will read the whole thing, but in real life work on the basis that your client or your boss is only going to read the first page. And you have to get everything that's important on that first page. Okay, when I look at what's going on with you in the classroom, I lose my ability to move my slides. I've worked it out. So your conclusions, they need to be brief. They should summarise your main arguments and state clearly where you landed. They should not, cannot introduce anything new, and they need to be logically consistent with the argument. So the number of times that I have read memos that I'm reading along and I'm thinking, yeah, I can see exactly, this person thinks there's definitely a contract, and then I read that last paragraph and they say no contract. Then there's a lack of a logical consistency there. So we need it to follow through. Less and less relevant here is legislation. Now, clearly that slide, something's gone wrong with it. It's not animating, but you've got the slides. You can have a look at it before at some later stage. Effectively, what the slide says underneath the box, which says don't worry about it too much here because you've been specifically asked not to spend your time on legislation. I need to know that you understand how the common law works. But if you're writing about a piece of legislation, legislation is probably the one area where you do want to set out verbatim, word for word, exactly what the legislation is. Usually the best way to do that is to attach a photocopy at the back of your memo. So at risk of oversimplifying, this is what you need to do. You need to be clear on what the question is. Then you need to identify the issues that you need to solve in order to answer that question. Then you need to identify the relevant law or rules that apply to those issues. Sometimes when we look at what the rules are, we realize there might be some more issues. And so you're finding that you've got to do a bit of iteration to get that bit right. Every time you've got a bit of law, you need to have a source for it. You need to then apply that law to the facts and predict how a court is likely to respond in order to give an answer to the question that you've been asked. So there are a couple of slides that are going here. Now, you've got the slide pack. I'm not going to read out the detail of them, or we will be here for a very, very long time indeed. But here what I want you to be doing is having a look at how to write these sections. So ultimately what you're trying to do is predict what a court would do. Now it's very rare that you need to do this amount of work if the law is super clear, right? And to be fair, it's not too complicated, this particular problem, but what I want you to practice is working out how to solve the problem and then articulate it in the way that a lawyer would. So what you're doing is predicting what the likely outcome would be. I like to use the words, when I'm talking about it, tentative conclusion or my predicted outcome. On balance, you think it's more likely that there is a contract, more likely that there's not a contract, and explain it in that way. Use leading cases where you can. So let me give you an example there. We spoke about a case last time we were together in the lecture, Fitness First and Chong. So that case basically articulates very clearly a rule which is effectively, if somebody signs something, then even if they didn't read it, they still can be bound by those terms, even though there was clearly no evidence of a meeting of the minds. That is actually the rule in Lestrange and Graucob, which is an English case, and the most or the highest level authority for that rule in Australia is most probably the Toll and Alpha Farm case. I used the Chong and Fitness First case, Fitness First and Chong, because I think it's a nice simple outline of what the facts were. It's really easy to understand in comparison to trying to work out who's who in the zoo in the Alpha Farm case. But at the end of the day, we want to use leading authorities when we're coming down and giving some sort of advice. It is important to look at both sides of the issue. It is really important to identify how you might be wrong, because your job is not to argue a case, but ultimately to tell your boss what they should advise the client. And at this early stage, you're not in litigation yet. Nobody's made a choice that it is worth pursuing. Instead, what you're doing is advising the client so that they can make some decisions. So that means don't ignore uncertainties, inconsistencies, ambiguities, conflicts. Don't confuse the law. Be as clear as you can so that the client can get the benefit of all of the information. Okay, something's flicking here, so I've got somebody talking. Oh, somebody, still audio issues. Sorry guys, I'm looking as much as I can. It appears to be a little bit better. I've noticed there's something to the slide pack. I distributed it today. It should be in the audio sections this particular one is in the materials relating to the first assignment. I need to understand your reasoning. So it's not enough to just say, these are the facts, these are the rules, this is the answer. I need you to do that application. The rule applies to these facts in this way. These facts are analogous with blah, blah, blah case. Or if you can't find an analogous case, the law applies in this way and logically it would apply in this way to these facts. Think about the way you're writing it too. You've got 3 or 4 different sort of sets of potential parties to contracts in this one. Think about how to set that out so that if it turns into something bigger, that each one of them can be dealt with separately. Think about the signposting, headings that you use, the way that you number, and think about how consistent and logical you're being, because all of that counts, particularly towards your writing. In the real world, if there are logistical, practical constraints, and don't we all know a lot about logistical and practical constraints at the moment, that force you to rely solely on secondary sources, then you need to say so. This is real life advice in relation to an assignment, including in the assignment, yeah, I'm really just having a tough time making it work from home, so there were logistical constraints that meant I didn't do the research. It's not going to work so much. You need to also think about what's missing. So often the difference between credit papers and distinction papers, or even distinction and high distinction papers, is that the higher ones will have also thought about what else do I need to know? What other bits of information are there? What does Dennis need to ask the client in order for me to be able to really make sure that my advice is correct? And the one that I cannot stress highly enough is, have you answered the question? All those words, if Dennis walks away from it still not knowing what you think, that is such a shame. Referencing. Referencing is really fraught, but it's really important. In real life, best thing to do is actually talk to your boss and ask what they want. I generally, when I was a partner in a law firm, I wanted everything. I want to know everything that you looked at. Partly because by knowing what you looked at, I can think, would I have looked in the same places? If the answer to that is yes, then, and you know, because I already trust you, you're smart, I didn't hire you otherwise. If you looked in the same places I would have looked, I've got more confidence in the answer that you're giving me. If you look somewhere different from me, that helps me think about the way that you're approaching it as well. They might also look for how many hits they have, how important something was. We don't need to do that here. In this assignment, you have been asked to reference using AGLC 4, and you have been asked to include a full list of everything that you've looked at, a full reference list. And people who don't do that, it's very hard for me to reward you higher because firstly, you're not following the instructions, but secondly, it goes to the writing element of your grade. Form matters, but ultimately substance is more important than form. One of the reasons that we mark to a rubric and you've got a separate section for the way that you write is that I will find ways to make sure that you've covered the content. So those of you who in the past, because you write well, have always gotten great marks, might not happen this time because the content needs to be there. Not saying that you wouldn't have the content there, but I've seen it. So you need to make sure that you have supported all your statements with citations and primary sources where possible, so cases or legislation as opposed to other materials. You need to distinguish between the cases based on hierarchy, so make sure, and I've mentioned this before, that you go with the leading cases, but if you can't find a leading case, find a little case if you have to. And if there's nothing at all in the primary sources category, then use what your textbook says. So let me show you, this is sort of my little mud map here that I just made today. Have you got a statement of the law? If it's not a statement of the law, then ask yourself, should it be? Have I actually got a statement of law supporting this argument? If you don't, maybe it's an opinion. It might be your own opinion. If it's your own opinion, can you cite somebody who agrees with you? Even better, can you cite someone who doesn't agree and explain why they're wrong? Probably more relevant in a critical analysis piece than in something like this, but it is worth bearing in mind. If it's an opinion and it's somebody else's opinion, then you need to cite it. Similarly, if it's a statement or fact of the law, sorry, I'm having trouble coordinating my pointer here. If the answer to that question is yes, you need to cite it. Primary source is best, secondary source, ideally peer-reviewed next. It's a pretty straightforward decision tree at the end of the day, and it's important to do it. Do you add appendices? They won't get counted in your word count. I'd probably prefer that you didn't, but sometimes people have to. They might have a diagram or a map or some, some glossary, some additional resources, all of that, that's fine. But think about it. Sometimes when you're in the real world, you might want to attach a copy of a case or a longer quotation. But if you're going to do that, particularly in the real world, make sure that you've done it in an organised way. This is where having a table of contents or something is particularly useful. I do want to spend a little bit of time talking about language. Think about tenses. Most guidelines suggest that you state facts and court decisions in the past, things that have happened in the past, we talk about the past tense. Legal rules, we use them in the present tense because that's what the rules are right now, unless of course we're talking about a law that's changed. And recommendations, they're prospective. We look into the future. Please advise our client to do this, so future tense. When you are choosing your words, be careful. Words like I believe, I feel, I'm leaning towards, they make you sound wishy-washy. And the ultimate client doesn't want to know how you feel. They just want the answer to their question. In real world too, if you're still investigating, say so. If you need to do further work, say so. But again, as I mentioned before, they're probably not great tactics to say, yes, I need to do more research on this point in an assessment task. One of my writing heroes, this handsome chap here, Justice Kirby, has written a lovely piece that's quite easy to get hold of, his 10 writing rules. And some of these are particular favourites of mine. I seem to have misorganised the slides. I'll come back to that. Oh, something's gone wrong here. Don't tell me. I had another slide with him just with a quotation from the conference at which he delivered this paper in 2016. I'll make sure that's available to you. It probably is available to you. I've just opened the older version of the slide pack by accident. So that they will explain. Just realised there's 11 in his 10 writing rules. That's pretty silly. Delete unnecessary rules. Maybe it's a kind of joke that the unnecessary words, that last 11th one. Number 10, his reference to preferring Germanic words of the kitchen to French words of the court. This comes from the larger paper where he is talking about how one of the reasons why writing in English is so difficult is that we culturally come from a place where we write in a very formal style, particularly lawyers, but we speak in an informal style. And these days, when the intention of a memo is to make sure you are understood, plain language is preferred. Not exactly written in plain language, but I do like this quote from Homer Moyer. Avoid legalisms. Latin phrases, abbreviations and other legalisms are the badges of legal writing. However, they are commonly redundant, usually pretentious and invariably unnecessary. When legalisms punctuate a paragraph, readability suffers. Like lavish capitalisation, frequent exclamation marks, and underscoring for emphasis, legalisms serve as crutches when plain English would nicely suffice. The addition of supra, arguendo, or inter alia rarely amplifies a thought. So let me pull some of those things out. Particularly when you're writing, use the active voice. Avoid passive language. This quote from Brian Garner, who is actually an American academic who writes about plain language drafting. Think of it this way: if you're active, you do things. If you're passive, things are done to you. It's the same with subjects of sentences. In an active voice construction, the subject does something. The court dismissed the appeal. In a passive voice construction, something is done to the subject. The appeal was dismissed by the court. This is important, particularly of those of you who might have come through an honours year doing a research paper, because traditional academic writing often requires the passive language because what we're doing is putting our research ahead of the author. But in modern, plain English drafting or legal language, we use the active to avoid misunderstandings and confusion. Another thing that legal writers are prone to doing is to normalize verbs. In other words, they're converting verbs to nouns. This can be really confusing for readers. So there was a committee agreement, should be something like the committee agreed. Her reporting of the event, she reported the event. So we can spot nominalised verbs by looking for these kinds of endings, the als, the ments, the ents, the ities. So think about that. Sometimes in contract drafting, we're trying to use language consistently, so there will be a technical reason for needing to use that verb noun normalisation, but in an advice memo there is no excuse for it. I've said this a number of times, words are like money. Invest in the best possible places. very few clients will ever say to you, I would like a really long memorandum, please. What they say is, can you do it in a page? Or more likely these days, they'll say, I don't want to swipe more than twice on my phone. Think about the ways that you can be concise and precise. Use the active voice, we've already spoken about that. Use concrete rather than abstract language. Be clear. Cut out all of those word-wasted idioms. He was aware of the fact that, when you could say he knew, for example. Also, like I've done here, use a list. Break things down into a list. It makes it easy for your reader to read them. Size matters and shorter is better. This is true of paragraphs. It's also true of sentences. So avoid run-on sentences. Really try and stick to one idea per paragraph. I'll be really quick here. Spell check is not always your friend. Make sure you are using the right homophone. Effect and affect have different meanings, as do ensure and insure. There. To, it, its. So check for those things. Legalese words, it's like swearing. They're not funny and they don't make you look clever. Although I swear all the time, but I'm neither funny nor clever. Any profession has its jargon. I can't bear it. I don't even like legal Latin. If you can say it in plain English, you should. The infamous RBG. So words like aforementioned, use previously stated or previously. Utilise, use. At the present time, how about now or currently? Subsequent to, after, inter alia, among other things. Arguendo, for the sake of argument. The list goes on. Also, I've got on these next two slides, I won't go through each of them, other examples of those long-winded ways of saying things, the compound constructions. So you can have a look at those in your own time. I've got, and come back and have a look at these. These come from again, an American site, interestingly, because on the whole, American drafting is way behind Australian drafting when it comes to plain English. But Columbia Law School has a really good set of plain English drafting resources. They have a plain language drafting course. And so I've got two paragraphs that effectively say the same thing. The longer one is passive language using the old-fashioned language, and you will see that the second one is significantly better. Citations, get them right. Think about the best way to do it. Think about what you're really trying to do here. You're trying to tell us what the law is, not tell us what the case is. So again, I think it's a really good idea to think about the positioning, particularly when you're going to use in-text references. And there'll be times when in-text references make a lot of sense when you're writing to another lawyer. So the example I've given here is that it's better to let the citation stand alone at the end of a sentence or a paragraph on the for the most part, because that allows your reader to get the important stuff which is at the beginning of the sentence. So rather than have something like in place of development and Commonwealth bracket 1969 blah 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 blah, the court held blah 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 blah, instead the law is clear that blah 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 blah, see place of development, or even footnote it. You don't even have to read it out loud. Also, avoid string citations. I spoke about this briefly in the tute last night, and I'll be getting the audio up for that shortly. One of the tricks for young players here is it can be really easy for you to want to show me that you know every relevant case. But the more cases that you cite, the harder it is for me to be able to tell if you know what the most important case is. So the best way to cite a case is to have the leading case and pinpoint. So identify where in the judgment the judge said the thing that supports the thing that you are trying to say. Now, it might make sense to have other significant citations as well, but when you have tons and tons of them, then actually the gold dust can get lost in the general noise of everything else that's going on. Excessive use of footnotes. Lawyers love footnotes. They really love it because you've done all this hard work, right? And it continues on into the profession. So every little interesting point that you have that doesn't really count, you think, oh, okay, I can put it in a footnote. You know, if it matters, it needs to be covered in the body. Now, footnotes don't get counted, and sometimes that's a really great way for you to be able to incorporate this really important information that you've found. But just be careful about it, that it doesn't overwhelm the most important, the most salient points that you're trying to get across. On the whole too, legal writers use a lot of quotations. Some advice I often give in relation to quotations is have a look at the way your textbook does it. There are lots of quotations in there, but they rarely go over 3 lines. And they're there to amplify and to exemplify the points that are being made. Some last bits of advice. Make sure you review the assessment criteria. You can find that in Canvas. Proofread every single word. If you can get somebody else to help you proofread it, one of the things that I find really useful is get your phone or PDF reader software or Cortana or Siri, depending on what operating system you're working in, to read your work out loud. That unforgiving robot voice will be your friend because our eyes see what they want to see, they see what they expect to see. Robot voice reads it exactly as written and punctuated, and you will hear where it doesn't make sense. Have a look at the rubric. You can see that there are these 5 different areas, very similar rubric to what you've been seeing for those of you who've been doing the discussion tasks. There is a more fulsome version of the rubric available for download in the assessment area. This will give you a good understanding of what I am looking for in relation to each of the criteria. Cannot stress it enough. Make sure you answer the question. I mean it. I really want you to answer the question. I really, really, really want you to answer the question. Questions, concerns, frustrations. Let's have a look. I love that you guys are all chatting amongst yourselves here. I look forward to going through. Do we have any questions? Let me just... Some tips for identifying the leading case. Well, Carl Hill and Carbolic Smoke Ball will always help. I'm not really comfortable with answering questions directly related to the assignment. Generally speaking, how would you work out what's the leading case? You are going to break this down logically. You're going to think about, well, what are the material facts? What's really important here? What is it that I need to share with the world? Sorry, Michael just said leading case in general, not for this assignment. So you're breaking it down as to, well, what are the issues? And then what are the rules that apply to those issues? So and you'll remember when I gave you that sort of XY of working out, well, what's the most important issue that you have to solve? What's the trickiest area of the law? The higher that something fits on that kind of XY continuum of how complex is it and how important is it to solving this case, the more likely it is to be a, if not the leading case. Now, I can't promise you that there'll only be one case each time. Then, once you've worked out what the rule is, then you're looking at the cases that apply to it and you're starting to think through, okay, is this really old or modern law? Is there an Australian citation? Is there a High Court citation? So some of the stuff that I was talking about, and I don't know whether this was before or after your question came through, Michael, was the example I used of the difference between using Fitness First and Chong and Toll and Alpha Farm. Toll and Alpha Farm is a, if not the leading case on the question of whether a signature means that there will be an agreement even if there hasn't been a meeting of the minds, a true meeting of the minds. But I've used Fitness First and Chong in our class because it's a simple way of identifying that. But if we're talking about actually substantiating the point, then I want to bring the leading case to your mind, and so that you know that there is a High Court decision, and in fact that one is the full bench of the High Court, which says exactly those things. Hopefully that answers your question. Actually, Michael, can I put you, if you got 500 options, okay, can I put you on, no I can't, because I can't work out how to do it. Good way to do it is to work out which is the best. What's the most recent at the highest court? If you've got 500 options, I'm pretty sure you won't have 500 options. How do you find that out? Ostley, actually I'm not sure how to do it in Ostley off the top of my head. First Point, which is one of the databases, and also Jade, both will show you what has been cited. Now, cited. See, now I'm nominalizing verbs. So what has been cited? So if you go into Jade, for any case that you're looking at, there's a little link that you can look at to look at where this case has been cited. So you can see whether or not it's moved further up the chain, has it been appealed, so you can look at the litigation history, but you can also look at whether it has been cited subsequently or not. First Point, from memory, has a little coding system that shows you whether it's been cited with approval or otherwise. So those things will help you, and you can follow the chain. In Jade, you are actually able to look at the whole litigation history, and you can look at the principle. It's got this kind of cool visual tool for helping you do that. Textbooks are useful for that. Actually, just at risk of wandering away for a second, I am here. I just want to show you something, because it's a little bit hard at the moment. This book, which is put together by a couple of barristers a few years ago, it's a Federation Press book. I'm not sure if it's been updated recently, but effectively what they've done is ranked in order the 100 cases that are most often cited in legislation, in decisions, in Australian decisions. It's got a summary of each of those and what the principle is. It can be actually a really rewarding little read. It's kind of like a primer to everything you need to know in law school. Somebody's asked a question, should you include cases that can be used as a counter case, especially in cases where a judge made a comment in passing? So when we're talking about obiter, for example. Short answer is yes, in fact you should do that, particularly if the point is unclear. Like, don't look for a lack of clarity for the sake of it, but if your point is unclear, if there are two different ways of looking at it, then absolutely you actually have an ethical responsibility when you're advising your client to make sure that you have shown both points of view. Does that answer your question? Okay, if everybody's happy, I will take many. Oh, we've got some more. No, I will take. I'm more than happy to take questions in the discussion board that's attached to the assignment. I'll go back and I will have a look at them. And we can, at the tute, have a even better look at any of the questions that come up. Now you've got this guidance. But what I'd like to do is change my slide pack, have a drink of water and stretch my legs for a second or two.